Okay, we started our week 3 yesterday with interpretation, and we will be proceeding still in our week 3. We have other topics, plain language. We have plain language to deal with. Plain language, then gender neutral legislative drafting and other aspects of legislative drafting. So we will deal with that today and tomorrow before we venture into our assignments. Our erudite professor is on the call. Prof, good afternoon once again and welcome. So we'll be handing over the floor to Prof for today's class. Thank you, sir.
All right, so welcome to today's lecture. Today we are continuing. 1 minute. Today we are continuing the lecture. We said something that if you were here at the beginning, we said there's a difference between a mechanic and an automobile engineer. There's a difference between a bricklayer and an architect. So this course, who can remember what is the difference between a mechanic and an automobile engineer? Both of them can repair a car. But what is the difference? What distinguishes them? A bricklayer and an architect, both of them can build a house. A mechanic and an automobile engineer, both of them can repair a car. However, what is the major difference between a mechanic and an automobile engineer? You can raise your hand and answer. If you were here from the beginning, please share. Yes, Oscar. Mr. Oscar. Okay, you started well, but you have mixed up two. Both of them have practical knowledge. You use the word, one has technical knowledge, technical. Any other person wants to attempt? What is the difference between a mechanic and an automobile engineer? Both of them can repair a car. A bricklayer and an architect, both of them can build a house. But what is the difference? What is the difference? For those of you here in Maseru, if you answer correctly, you get a copy of this book. For those in Maseru. Yes, Shetak, Madam Shetak.
Yes, sir. For me, I would think the end product, the finis of the service would differ.
Okay, you have put it down to the end product. You're correct. Something else I'm looking for. So we have technical knowledge. Now you have mentioned finesse. The products, yes, you're right. Yes, Mr. Solomon Young.
Okay. My opinion, the mechanical person is not schooled. He's not schooled. He just learns like an apprentice and he knows how to do the work. But the automobile engineer, gets his qualification by schooling. He gets his skills and the things he's able to do by going to school, and then he obtains the certificates that enables him to know the skill properly in order to handle the work that he's doing. That's my understanding.
Excellent, excellent. You have beat around the bush, but there's a word I'm looking for. Itabeleng, please.
That in the case of a bricklayer and an architect, they can both do the work. They can build a house. But an architect have studied principles involved in construction and building the house, whereas The bricklayer can only build a house.
Okay, that's good. There's a word I'm looking for. Ita Beleng, do you want to try? Can you unmute your mic? Ita Beleng. All right.
Famose, you can talk. Famose. Famose, you have the floor. Can she hear? Okay.
All right, back to Solomon. Do you have the word now?
Yes, I also want to venture into the architect and the builder. Whereas the architect deals with aesthetics, deals with how to bring out the beauty in terms of designing a building or a structure. The builder is the one that is involved in the practical doing to apply what the architect has put in writings, like the legislature and the judiciary.
Right. Thank you, Solomon. Uju, do you want to try? There's a word
Yes,
I'm
sir.
looking for. We have not got it.
Okay,
Yes.
one of them is a professional because he undergo formal training. Thank you.
Thank you so much. Yes, Ran Sewer.
Thank you, Prof. I think one is rather limited in knowledge compared to the other, in the sense that for the mechanic, his knowledge is limited only to the design already created. But the engineer is able to improvise, maybe even go beyond the original design, because the original concept is his.
Thank you. Tumelo.
Thank you very much, Professor. I think the difference between the two professions is the rules of hierarchy which they comply to. The fact that an engineer would, in creating his product, look at the laws of physics and how they interplay with the creation. But the mechanic on the other side would have to succumb to the guidelines that the engineer has set as rules that will make sure that the product functions well. So I would say the difference between them is the hierarchy at which they are able to both invest in the creation, one being higher than the other, at least as far as to how the product should be used, and the other being higher than the other as far as fixing the product when it is now in use. Thank you, Prof.
All right, thank you. You've all hit the nail, but the prize goes to Uju Obi. Unfortunately, you are not in Lesotho, so we cannot give you a copy of this book. Maybe when I'm back to Nigeria, remind me, I'll give you a copy. So you hit the nail on the head.
Thank you, sir.
One of them is a professional and has undergone formal training, whereas the mechanic undergoes apprenticeship, on-the-job training. Remember when we were saying before now, legislative drafting was taught only on the job training. You have to join the Office of Parliamentary Council to learn legislative drafting. However, we have moved away from that sole reliance on the job training. Now we have formal training in legislative drafting. When you combine on the job training with formal training, you become a complete legislative drafting lawyer. One of you mentioned physics, the laws. An engineer knows the laws of physics. You learn these things through formal training, these principles. If you rely only on the job training, you learn by drafting from precedent alone, but you do not know the principles behind drafting. You only learn on the job. Okay, this is how you draft treaties. This is how you draft subsidiary legislation. You copy a precedent. But the principles behind them, you do not know. This is when your knowledge of formal training combines with on-the-job training. It is through formal training that you learn the principles of legislative drafting. Why are things drafted the way they are? Why is the long title here? Why? One of you asked the question, why do we not use objects and a statement of purpose? Circumstance. So it affects their style of drafting. In civil law tradition, a law can be one page. Their laws are shorter. Remember, common law is different. Everything has to be literal. Remember the mongoose principle we learned yesterday. In common law jurisdiction, we write longer legislation because everything has to be expressly stated. Whereas in civil law tradition, the laws are shorter because they have what they call the purpose clause. Once there's a purpose clause in any law, the judge has discretion. The discretion of the judge in a civil law tradition, legal system, is wider than the discretion given to a judge in a common law tradition. So it affects the way their laws look like. So in a civil law, legal sees the purpose clause, he can interpret that law anyhow based on the circumstances of the case. So their laws are usually shorter, one page, because once they have written the purpose clause says, this is the purpose of this law. Once they have written it, the drafter has done his work. So the rest is left for the judge. But you know, in common law tradition, you cannot just write the purpose of this law is blah, 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 and you leave it at that. The judge has no power in common law tradition to read meaning or add what is not written. That is why judges in common law say, my hands are tied. They cannot add anything to that legislation if the drafter has not put it there. So this is a fundamental difference between civil law and common law. When you know this principle, your style of drafting, it affects your style of drafting. In common law jurisdictions, we do not use statement of objects or purpose clause. The reason is the principle of legislative drafting in common law is that you do not use superfluous words. Every statement in any legislation must carry the force of law. Nothing is nugatory. I'm going to spell nugatory. The principle of legislative drafting in common law jurisdiction is that nothing is nugatory. Look at the spelling of nugatory in the chat box. Nugatory means null and void. You cannot write any statement in any legislation that is null. That is the difference between legislative drafting and other forms of writing is that we are not writing literature. Literature is for entertainment, but legislation carries a force of law. Every word, every statement in a legislation carries the force of law. It is not nugatory. It is not aspirational. Aspirational. Legislation does not contain aspirational norms. This is what distinguishes legislation from other forms of writing. So, you need to know this basic difference. In common law tradition, whatever you write in legislation, in a bill, is supposed to carry a force of law. It should be enforceable. Either you are taking away rights from people or you are conferring rights. That is what legislation is about. Legislation is not a statement of objectives. That is the problem we have in Nigeria and even in Lesotho. The Constitution, you have in Nigeria, Chapter 4 of our Constitution, statement of fundamental objectives, which are not justiciable. In a legislation, you cannot have a statement of objectives which you cannot enforce, because the definition of legislation is that it is a statement of rights. It confers rights or takes away rights. So it must be enforceable. Nothing should be stated as an objective. That is why Chapter 4 of the Nigerian Constitution, you cannot enforce it. In Lesotho too, you have part of your constitution, statement of objectives. The government shall take steps to protect the environment. Meanwhile, nobody can go to court for that. The drafters of the Constitution failed because they did not understand the principles of legislative drafting that apply to common law jurisdiction. In common law jurisdictions, we do not write a statement of objects or objectives. Because in law, in legislation, you cannot have objectives, aspirational norms. Oh, one day. No. Legislation is a statement of rights, confers rights, privileges, or takes away rights and privileges. It is not a statement of aspiration. If you want to write aspirations, you cross over to literature. You write prose, you write poetry, you write drama. That's the field for such kind of writing. In legislative drafting, we are writing statements of rights privileges which the law confers or takes away. So this is a fundamental difference between drafting in common law and civil law jurisdictions. Now, I posted a lot of materials for you. One of the materials was written by my colleague at the National Institute for Legislative Studies in Nigeria. He made a case for Nigeria to copy the civil law tradition of writing statement of purpose. And he now cited an example in the laws of Nigeria. The example he cited is called Environmental Impact Assessment Act 1992. If you study the legislative history of that law, it was passed during the military era. It was copied hook, line, and sinker from Norway. Norway is a civil law country. So section 2 of that law is a statement of purpose. So those who do not know say, oh, Nigeria has started using statement of purpose in their laws. The history of that law is that that law was copied hook, line, and sinker from a civil law tradition. A country, Norway is a civil law country. So in their laws, they always have statement of purpose. So the drafters who copied that law did not think to remove that part of the law. They just copied hook, line, and sinker. So this is the difference between a mechanic and an automobile engineer. A mechanic will just copy precedents, but an automobile engineer, a legislative drafting lawyer who has undergone formal training in addition to the on-the-job training, you know better than copying hook, line, and sinker. Because the legal traditions are different. Those of you who are in the LLM class, there's a course that is called Comparative Legislative Drafting. It is to equip you to know that in law, there's a field of law called comparative law. Comparative law is that field of law that teaches you that, yes, you can copy from foreign jurisdictions. However, there's a caveat. You don't copy hook, line, and sinker from foreign jurisdictions. You don't copy legal concepts, hook, line, and sinker from abroad. There's a caveat. Before you copy, you must perform what we call the functionality test. Functionality test means you need to ask yourself, this foreign legal concept, when I bring it to my country, will it function? Function means, is it going to blend into my legal system? Then any part of that foreign legal concept that will not work in your country, you have to remove that part. So this is what your understanding of the principles of legislative drafting, it makes you a better legislative drafting lawyer. Otherwise, you keep creating problems for yourself, such as the problem that the drafters of the 1999 Constitution have created for us. A whole chapter filled with legal jargon. However, it is not enforceable because the drafters put aspirational norms which are not enforceable, which is a clear violation of the principle of legislative drafting that says legislative drafting is a statement of rights, confers privileges which are enforceable. You cannot have a law that contains things that are not enforceable. If you look through your laws, you will find the Constitution, especially. The drafters did not understand these principles. They copied whatever they copied, put in the Constitution. And today we have parts of the Constitution that are not enforceable. So this understanding, you need to understand the difference between common law and civil law. I'll tell you a history. Part of the materials I sent to you, you will read Lord Denning, one of the most respected judges we have ever had in the common law system. In 1978, he made an attempt to try to import the purpose or purposive approach to legislative drafting. He tried it in one of his judgments. He delivered a minority judgment. You know, there's a lead judgment, then there's a minority judgment. He made a case. He said, England, United Kingdom should apply purposive approach to legislative drafting. Well, you know those people, they said, okay, we have heard you. They set up a committee. It's called the Renting Committee. I'll spell it here. You can go online and read about it. The Renting Committee. The whole purpose of that committee, it was headed by a judge of the Supreme Court. That committee looked at the suggestion by Lord Denning. How can the UK, a common law country, switch over to a purposive approach, which is a civil law tradition? By the time they looked at it holistically, they set up this committee, they looked at this, what do we need to do to implement purposive approach to legislative interpretation? They came up with a conclusion. They said, no, we cannot switch to purposive style of interpretation because it requires changes to our legal education curriculum. Because in the civil law tradition, you are trained as a lawyer. In your final year, you have to decide, will you be a magistrate, will you be a prosecutor, or will you be a lawyer? You have a choice. In your final year, their legal education is 7 years. But in your final years, you have to make a decision. Either you are a private lawyer, or you work as a prosecutor, or you work as a magistrate. That's when you make your decision. Because all these career paths, they are set out based on their legal system. So if England was going to adopt the civil law tradition, their legal education curriculum needed to change fundamentally. And they said, no, we don't want that. So, and also their style of drafting would have changed fundamentally. They said, no, we do not want that. So they continued with their common law tradition. Now, this is something that we all have to understand because the rules of interpretation in common law are different from the rules of interpretation of civil law tradition. So you cannot just go and copy their style and come into your country. There are basic and fundamental differences. So for example, in Nigeria we have what we call the Cyber Crimes Act 2015. It is a law that criminalizes crime that is committed by use of internet and other electronic devices. When that law was passed, Section 24 of that law, there was a problem with Section 24. It was in conflict with Section 36 of Section 3612 of the 1999 Constitution. Section 3612 of the 1999 Constitution says, no person shall be punished for any offense unless the offense is defined. Defined, notice the word defined, in a written law, and then penalty prescribed. So the problem with Section 24 of the Cyber Crimes Act is that a crime was mentioned but not defined. The crime was cyber stalking. I'll spell it in the box. A crime was mentioned in that law that legislation, cyber stalking. This is a crime. However, the definition of that crime was not provided in Section 24 of the Cyber Crimes Act. Definition means, you know, as lawyers, every crime has two elements, the mental element and the physical element. These two must be defined for a crime to exist. However, the drafters of that Cyber Crimes Act did not provide what is cyber stalking, what constitutes the mental element, what constitutes the physical element, actus reus, mens rea. They did not provide it. They just said, if you commit cyber stalking, you'll be sentenced to 14 years in prison. Now, this case went to court. It was tested in court in the case of Inspector General of Police versus Kemi Olumoloye. There's a journalist, online blogger. She was accused of committing the crime of cyber stalking. When the matter went to court, the lawyer for the journalist stood up and said, "My lord, I have a preliminary objection. By virtue of Section 3612 of the Constitution of Nigeria, this journalist cannot be sentenced to 14 years in prison because the crime was not defined." Yes, 14 years was stated, but the crime, the definition was not provided. And the judge says, "My hands are tied. This woman, this journalist has to go free because there was no definition of that crime." Now, this is a common law jurisdiction, Nigeria. However, if this has happened in a civil law country, such as France, the judge would not take the same decision. The judge would have looked at that law, looked at the purpose clause. Once there's a purpose clause in any law, in civil law jurisdiction, the judge can use that to impose penalty. So you can see the difference between common law and civil law, their style of drafting and even interpretation, how it works out. So I thought it's very important you know these two principles, so that even when you go online to copy a precedent yourself, this precedent, is it from a civil law country or a common law country? Then you will know that in copying that precedent, it is not everything you have to copy. You should not copy the purpose clause. It is important you know these differences. Any questions? 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 You can unmute. We have a few minutes left. Any questions? We posted.
Hello. Can we have the full citation of the stalking case so that we can read in order to appreciate?
Okay.
We'll probably have more questions.
Inspector General of Police, that's Nigeria, versus Kemi is spelled Kemi Olunoyo. Things like this. The complainant to search for it. I'll put it there. What was resent of objects and purpose? Should we continue? If something wrong, you can correct that. Although it's for the lawyers at the Office of Parliamentary Counsel. If a member of the National Assembly to draft a law, now that you know that statement of object
Prof,
Yes.
I have a question, sir.
Go ahead.
Do I understand you to be saying that in civil law jurisdiction, a judge can actually text the language that appears on a statute to convey a different meaning as long as it is in line with the People's Clause?
More discretion on judges.
Second question, sir. If they are able to do that, I mean, isn't that in a way sort of a similar thing that in the process of maybe deliberating or interpreting or aligning to the People's Clause, can the process arrive at a decision that can be used later in a different case, like in a stare decisis sort of situation?
No, they do not have the principle of stare decisis in civil law jurisdiction.
Thank you, sir.
Yes, thank you. Any other questions?
Thank you, Prof. I was the one who had in previous classes asked about, so that I joined in late today, but am I correct that I understand you, Prof, to be saying
Yes,
objectives?
that's what I said.
Thank you.
You can ask.
Thank you, Prof. I'm wondering if does this mean the judges in the common law jurisdiction quite sort to the mischief rule, because that will necessitate trying to understand the purpose, so to say, or the reasons behind, or rather the mischief that that piece of legislation was trying to remedy. If in the event that maybe the literal rule is not, the meaning leads to ambiguity or inconsistency. Does that mean the reason that they now judges in this piece of legislation?
You are caught what is the golden rule, what is the literal rule? You know, sometimes you overthink and cause problem for yourself. Today's lecture was on purpose clause. I said in common law we do not use purpose clause, and I gave the reasons. Now you have twisted it the other way around and created confusion for yourself. Today's lecture is almost out of context to go and apply it to mischief. That's not how you create problems for yourself like that. I said in a legislation there's, and based on that, that's how their judges read their laws. So you don't mix. Mischief rule is different. Golden rule is different. Literal rule is completely different. So you have taken just one word, purpose. Just because purpose appears in mischief rule, you have now taken the purpose here to mischief rule. That's how you create problems for yourself. because you have left the context of purposive interpretation. I told you Lord Denning made a case. He wrote 1978. He wrote a judgment. He made a case, say common law should apply the purposive approach to interpretation. And the legal system in the United Kingdom, they told him, no, with due respect, Lord Denning, no. What you are seeking is a complete change to our legal